is that the right to dignity is the overarching right that should encompass all the other rights. So I just wanted to know how you placed that or situated that within the book.
Thank you so much. My question is for Dr. Ndjodi. Doctor, so in a situation where we have communities that do not have money, and the Constitution gives an explicit right to water, under what premise do municipalities then have to disconnect water for these poor constituents who do not have the money to pay for water?
I'm John Diaz, just a local guy. Just on that, basically building on this particular question that is given, if you have regard to the Mulima case that you referred to, Dr. Ndjodi, I don't know what kind of criticism you unleashed on the particular judgment in terms of your book, but highlighting some of the few things that I've just noted today as I was reading through your book, from pages 90 to 104, where you made the comparative analysis with India as well as Botswana. And obviously appreciating the fact that the right to livelihood as expounded upon in the Indian Constitution compared to our right to life, as basic as it is, and also what was said by Madam Jacobs herself about the right to human dignity. It's very crucial for us to understand that it has already been basically, there's a precedent that exists. If one has due regard to Florbla, and another is the Town Council of Walvis Bay, where it was explicitly held that you cannot rely on Article 23, Sub 2, if you want to impose laws to give right towards land, when the municipality basically made provision for land to be acquired by people of previously disadvantaged backgrounds. So when Justice Faniker was writing the judgment, she clearly said that for you to rely on Article 23, 2, read with 10, you must rely on a legislation that is passed. So since 2004, on the 14th of April, when that particular judgment was landed, nothing has been done. There's no political will that really will foster us to get land, number one, because Mr. Florbla said that because you are depriving me from a race that was previously advantaged, my right to human dignity is violated by this particular policy that the municipality is passing. You get it? So, stemming on exactly what he was saying, the gentleman over here, is that if we pass legislation, and I'm maybe giving also a takeaway to the political leader who's sitting here today with us, is that lobby for laws and legislation that really address the socio-economic rights within Article 95. Without that, we don't have a recourse, literally. And Malema, of course, according to Justice Olin, when he wrote the minority judgment, he was very explicit about how you peg that particular article within Chapter 3, relating particular article. I don't know what your criticism there is, but if you could just briefly share what it is. Thanks.
Thank you very much for those questions, and thank you very much, Judge Masuku and Advocate Busak, for those really engaging reflections and very generous in many respects. Perhaps to respond directly to the questions that were raised, Tony, thank you for coming. I think this book will find life if people such as yourself bring it to life, so I'm really delighted that you joined us. So dignity, I obviously gave careful thought as to which textual anchor I would utilize in order to found this Ubuntu approach to water, and I gave extensive treatment to the issue. I decided on life rather than dignity, because yes, there are arguments around dignity as a meta right, the right of rights, but I also wanted to tease out other dimensions, because my conception of Ubuntu has 4 principles, 4 legal and the argument can be sustained by a dignity approach, but of course for purposes of the argument that is advanced in the book, I decided to stick on one textual anchor, because it would just require so many other dimensions if I latched on to a different textual anchor. But I do have a bit of a discussion on the dignity element. The dignity jurisprudence of our Supreme Court is tenuous, if I can call it that. There's a lot to be said there. I think much of the jurisprudence has been in the context of sort of defamation and so forth. So that socioeconomic dimension hasn't been fully teased out. Hopefully we can see that being developed in coming jurisprudence. On the economic dimension, people who cannot pay, so that's a classic practical question as regards the right to water. And in this aqua notion, the availability and accessibility elements, or the accessibility particularly, includes economic accessibility. Now, the problem at local authority level is actually quite complex and in many ways also simple, because sometimes it's not necessarily the absence of water, but the fact that revenue isn't channeled to the water utility by the municipality, so the consumer, the bottom consumer, is paying to the local authority municipality, but that isn't being handed over to the water utility. So there's that gap, but the punishment, if you want, befalls the consumer directly rather than the local authority. So that clearly needs to be looked at much more closely. But that economic accessibility point is a pertinent one. There are people who practically cannot afford water, so the argument isn't necessarily that you shouldn't pay for water, but there is a minimum core, essential content of water, which everyone is guaranteed, irrespective of your economic means. But I encourage you to look at chapter 5 and 6, and hopefully that can allow you to form your own conclusion. John Diaz, you are clearly not a simple man. you have a comprehensive understanding of our jurisprudence. I haven't come across the Grobler matter. I will definitely will exchange, and you said the 2004 matter, so I'll pay attention to it. Mwilima. Interesting decision. My main criticism of Mwilima is that the approach to Article 95 and 101 that the Supreme Court took in 2002 was informed by an outdated understanding of principles of state policy / directive principles of state policy as they are known in India. So I looked at what the Supreme Court, how the Supreme Court reasoned, and then I looked at those secondary sources that the Supreme Court looked at. A particular scholar called De Villiers, who wrote about principles of state policy in the Namibian context at the dawn of the Constitution's adoption, 1991-1992. De Villiers then refers to other Indian scholars in the 70s and 60s and 80s when they were having their debate as to, why are these socioeconomic rights not justiciable? They arrived at the conclusion that directive principles are not a bar. So I say that actually the court relied on scholarly literature which was problematic, which then resulted in the problematic approach that it applied in Mwilima. So, like I said, the argument in the book is adumbrated, but that argument of principles of state policy is to be discussed in the article that I referred to that will be published soon. And I look at more widely the comparative perspectives and what Leil Wies, an Australian scholar, calls clauses such as Article 101 contrajudicative clauses. So you have Article 101 that says that you cannot enforce those principles of state policy in the courts, but they can be had regard to in the Constitution's interpretation. One scholar, Professor Zongwe, in a session we had this afternoon, called it a provision of confusion. It creates constitutional confusion if you interpret the Constitution in that way. But there are ways in which you can avoid such a constitutional confusion. It was expressed in a dissent in Mwilima by Chomba, AJA as he was, around rendering Chapter 11 and Article 101 effectively deadwood in the Constitution. So it's there in the text, but you just ignore it. So that's a concern that is legitimate, and I respond to that in the article that I referred to very briefly through a bounded, deliberative approach.
Through your book, the challenge is out there for practicing lawyers to somehow bring about an actual manifestation of the rights that you envisage in your book, that is the right to water. So, and I believe I speak for the lawyers when I say we are up to the challenge. The opportunity will avail once clients come about. And the fight will be on those for and against the right that you envisage in your book. But by nature of things, Dr. That won't be enough. As we might have had from the discussions to the book. For instance, we have a judiciary that will be very crucial in ensuring that that right find its way to the general public and citizens of this republic. For instance, we are confronted, as with all judiciary, by a judiciary which will in some instances be positivist judiciary, and with the converse of being activist judiciary. You know what the former entails? If you bring the case to me or litigation to me, I follow the law. If you want something beyond what is prescribed by the law, go back to the parliamentarians or the politicians to change. Whereas you might find favor with your judicial activists that will be willing to embrace what you refer to as an implied right within the context of social economic rights. So whereas you will find both those fighting for and against what you envisage in your book, the judiciary itself might not be the end result and end process towards ensuring that. So you might want to consider extending this type of forum to even parliamentarians and politicians, so that you do not have a right or an instance where at the end of extensive litigation coming all the way from the High Court to the Supreme Court, you find yourself with a judiciary that says, we understand you, we embrace your right, but this right is not explicit, it's not before us, and all types of other reasons relating to budgetary constraints that says our republic might not have funds to accommodate that right. So sensitivity in the similar format as you have done here with the legal practitioners might also be called for with our politicians, and you might want to take that cue. Thank you.
Legal Assistance Center. I have a question for Mr. Ndjodi, and it relates to the anchoring right that you have chosen. When we were at the book discussion at UNAM, it was asked by a gentleman that I believe he was from NAS. He said, or in my modest understanding, what he was asking was the context of Article 6 as a whole relates to a rather punitive type of article, in the sense that it prevents, or it wants to prevent the passing of laws that take the right to life away. Now, I just want to know how generous of an interpretation should we, or have you given, or how generous an argument have you made in your book with regards to constitutional interpretation in this regard? Maybe you can just expand on that.
Thank you very much. Mine is not really a question, but a more enticing view or a comment, particularly from Advocate Busak, and perhaps interpreted through the right to life in Article 6. But he says, he argues that it's a court enforceable right. Now, I did also hear Mr. Ndeunyema raise his concerns, although not in depth. That's why I'm trying to entice a further view in terms of the adversarial approach of our courts. Counsel, Tatish Kongo, also mentioned it and added further in terms of the positivistic approach. But Dr. Ndeunyema also said that he did do a comparative analysis. So mine is simple. in terms of, I've got my own views, but I want to understand, Counsel Advocate Pusak, in your view, what are the inhibitions? You did a comparison in terms of our findings in our courts in the Shanika case, and said they fell very short in terms of what was found in the Grootboom case. What are our inhibitions which are still putting us in this tunnel of positivism and adversarial approach? Thank you, that's mine. I've got my views, but I think it's a good platform for a discussion on this. And Dr. Ndeunyema, if it is that there are inhibitions, since you seem to be a bit more, someone called you, there was a word that was used, more adventurous. If it is that there are inhibitions, how can they be overcome? Thank you.
Thank you very much. I heard something about political will on the other side. But for political will to be exercised, we probably need to ask, does Article 6 places a positive obligation on the state? And if it does, perhaps we may answer whether that can be translated into a right to water.
Thank you so much for those questions. The speakers didn't identify themselves, so please do. Some of the speakers didn't identify themselves, so please do forgive me. So the comment, I believe it's by Mr. Shikongo. Thank you very much. I think really the reason why I was keen to not just have this book in a library somewhere and present it to an audience such as yourselves is that the book and its ideas can only have a chance of coming to life if lawyers such as yourselves take it forward in the arguments as Judge Masuku was encouraging us. And that is through the often painstaking process of strategic litigation. And it is painstaking. One of my PhD colleagues was researching strategic litigation in a South African context, and he typologizes the various forms of politics, law, and impact and how they come together. And he looked at the history of Grootboom, Treatment Action Campaign, Carl Michel, and all the resources, intellectual and material, that have gone into creating those golden pieces of jurisprudence in South African in the South African legal system that ultimately shaped not only how the Constitutional Court interpreted the Constitution, but also informed legislation and policy for a more socially just society. So it's definitely not an easy feat, but I think it's a coming together of efforts. So, Mr. Veya, the anchoring right point, again, I don't think it's a generous argument to say that there's a socio-economic dimension to life. And very briefly, I argue that through Ubuntu, so a philosophical conception. Now, my concern, especially with the rate of progress of Namibian jurisprudence, is the fact that we are extremely behind the curve. Now, we are debating a right to water, and there's still some people who are ambivalent as to the existence of the right to water, but the world has reached a consensus, and they've moved on to a right to electricity, a right to the internet, as a human right that is fundamentally enforceable. And if we look around today, if you do not have Wi-Fi, your right to education is nullified. Your right to political activity is not nullified. So the world has really moved on, and it's unfortunate that we're still here debating these issues of, oh, do we have a right to water at a very basic level? So how do we move and precipitate that debate is the challenge, because the world is really leaving us behind, and our jurisprudence, and I think many in the room would agree, has to progressively develop. That requires much more activism on the part of the courts, but of course the courts need to be fed with the resources to create that progressive jurisprudence, and I think that's our collective responsibility in taking that forward. Court enforceability, the legal culture, I think it's Mr. Shimtukeni, thank you for that perspective. The inhibitions, I touch on them briefly through this mirage of justiciability point, but I am not as well placed as many of you in the room to identify those issues. I flag it from a theoretical point of view, having not practiced in this jurisdiction, that these are the issues as well documented in resources by the Legal Assistance Center, and as recognized by central government, because many of these reports around the reform of the legal culture have been put forward by the Law Reform and Development Commission, but haven't found expression in legislation. But something needs to give if we are to ensure that we precipitate change and ensure that the courts are not just perceived to be dealing with criminal matters or accessible to those with economic and political power in the context of deprivations of their rights in as much as they have that right, but everyday Namibians who are facing social and economic challenges can seek and find refuge in our courts. And that, I think, will ultimately enhance the judiciary and the legitimacy of the state structure that we have adopted. On Dr. Itula's point, positive obligations, very briefly, the issue with Article 6 is that it refers to the state to the right to life. It doesn't say that the right to life must be fulfilled. But Article 6 isn't to be read in isolation. There's Article 5, which sets out that there are obligations that the courts can enforce, which includes a fulfilled dimension. There's an Article 25 provision, and even if there weren't those provisions, it's a foregone conclusion under international law that that typology of a trilogy of duties is recognized. So it would be extremely restrictive if our courts were to reject a socioeconomic dimension for positive duties on the part of the state because of the textual absence, going back again to us being haunted by these dead hands of the past. And that's not a pejorative expression per se. It's borrowed from American jurisprudence. We have the fortune of having the drafters of the Constitution either living or in living memory, but at the same time, they drafted the Constitution, but they do not dictate the forward-looking nature as to how we interpret the Constitution, this notion of the Constitution as a truly living instrument that is meant to be responsive to our socioeconomic realities. I think there are other points that the other discussants can reflect on.
Shimutukweni, I think you asked a very important question. What hinders us? And I must say, from our perspective as practicing lawyers in this jurisdiction, maybe one must preface any statement by saying we are first of all officers of the court, and we respect legitimacy of the courts. But we should also be able to express criticism of the courts and be able to engage with the courts on critical issues for the court to consider possible other ways of dealing with them. So we are fortunate in that regard, or possibly unfortunate from that perspective, that we have we have two sitting judges with us. So I just want to answer you by saying to you, how do we get to an adventurous level of litigation as Dr. Ndjodi is advancing here, when we sit with the situation that on the one hand we have obtained and a new system was implemented. That's fantastic. The e-justice system, it's fantastic, I must say that. And I say that in light of what our big brother down south is trying to do. It seems they are struggling with it. And there's only one province that's managed to come close to our e-justice system. So that's one fantastic thing that we have obtained in our system, thanks to the leadership of the JP. But we also have a case management system. A case management system that us who know and who practice in those courts on a daily basis, unfortunately know, have certain judges who end your case in a case management system. It's unfortunate to say it that way, but unfortunately by means of the requirements, the different steps, the compliances that needs to be met, unfortunately, a lot of matters end in that process without those matters being properly adjudicated. So we need to recognize that reality as well. And that reality has a financial component to it, unfortunately, as well. So the question begs whether litigation has become cheaper because of this system, or it has incrementally increased because of this system. We need to engage those issues. Some would argue that, unfortunately, they are more in court with the case management system than as opposed to maybe it was the situation previously. I do not criticize the system for saying it's a bad system. I think we need to engage the backlogs, the issues in the system in order to have a more efficient system. And once we do that, we come to the next issue that Judge Masuku had raised, locus. It's one of those issues. In South Africa, and Dr. Ndjodi mentioned the word strategic litigation, a group that's busy with strategic litigation in South Africa. And I was thinking, yes, they are able to do strategic litigation, because an issue of locus is not an issue that they have the way we have. As you know, in South Africa, they have the amicus scenario, that any interested party are able to approach the court and advance that position and make a legal argument for a particular grouping of people. So they don't have the locus problem. We do. So I'm not sure, as Judge Masuku indicated, that it's merely an issue of busybodies. It might be in some instances, but fundamentally, there may be locus issues, and the scheme of rules and our jurisprudence does not allow for the position that South Africa pertains to. And that problem we need to engage on, because arguably there might be a community out there similar to the communities with the Shanika matter. Stranded communities were evicted by local authorities who do not have the funds to pay counsel and attorneys. If there were a group who could act for them, like Amicus in South Africa, I mean, they would advance their interest in courts legitimately and to enforce their rights in the courts. Apart from not locus issue really, because their interests are personally affected, but as a grouping, a loosely banded grouping of people coming together, advancing a cause to the courts. And I must indicate this as an example. You might know the former members of the Rossing community that took on the Rossing pension fund. My experience with that community, a point in limine was taken initially in the High Court when we took that matter to court, is that community was not an association of people, or a properly organized and registered association in terms of our laws. So it was a loosely banded group of people with the same interest. So which means each person was an applicant. Each person in that particular scenario. Now can you imagine, you have hundreds of people, the logistics around that, as each person being a party to litigation, or what that entails. And not to mention, the Rossing pension fund took a legal point that the members of the pension fund had to be served individually. The current members of the pension fund, whilst we serve the mine workers union as a representative body of those exact same members. So whether that point was legitimate or not, that point is one of those types of points that are raised in our jurisprudence. So can you conceivably imagine that a community of a loosely banded group of people struggling to find legal funds to pay for their attorneys and counsel to go to court, now they need to incur the cost to make sure that all the members, current members of a union, who are pension bond members need to be served, as opposed to their representative bodies. So I put this in the light of the issue that you're asking. What hinders us? And it's an issue of, firstly, it's structurally our situation pertaining to our law as it is, whether it's the rules, how it operates, whether it's our legislation. And the reason I mentioned Kaweza and I mentioned Grootboom, I put that in the context of legislation and the Constitution. The Constitution not allowing the adventurous approach that South Africa may have had and taken in light of socio-economic rights, because in South Africa, clearly the Constitution allows the courts to do that. So I put it out there in that context. But similarly, I was restrained in the position that Mr. Chikongo had pointed out, and which is also a very important issue, is the approach of our courts, whether it be positivistic or, as we know, we textual interpreters of the law. And that is fundamental as well. So I do not know what your views are, whether our courts are more positivistic on the interpretation of our law, which some of us would seem to agree with. And I do not know if there is an adventurous activist approach to our law in our jurisprudence. But that conversation needs to be had with all relevant bodies, and I'm glad you asked that question, and we can all engage on that. Thank you.
Thank you so much, and Ndjodi, congratulations once again on such a fantastic piece of work. I'm personally very proud to be associated with you and very proud to have my name listed in that book. It's a great honor. In respect of the right to water, we should have regard to the general comments being made by the Treaty Body Committee on Economic, Social and Cultural Rights at the International Human Rights platforms. This committee has, during the consideration of Namibia's initial first and second report, state report on economic, social and cultural rights, made a comment, and there was quite a discussion around that, as to whether these rights that we are discussing tonight, especially the right to water, is in fact can be called a right. Can it be called a human right just for the mere fact of it not having any remedy when it is violated? So for a right to be a real right that can be enforced, there needs to be an option or the availability of a remedy in the case, for instance, of the violation of that right. Now, until such time that we, as Namibia, recognize the right to water as a fundamental human right, it means that we cannot enforce that right. And a right that cannot be enforced and that doesn't carry with it any remedies in the case of violations cannot then be called a human right in the opinion of the committee. And I am saying that because the judicial enforcement of human rights is really fundamental. Where do we go to when our rights are violated? We should be able to go to our courts. In the event of that right not being recognized as a right, then there will be no remedy. And whilst judicial enforcement is definitely not the only way of securing the promotion, protection and fulfillment of rights, it can definitely assist in giving clear guidance and clear interpretation of the issues surrounding those rights. So I would say that the time has come for us to really now start thinking about how we are treating the least privileged in our societies. If we as Namibia as a nation are vigorously participating in discussions on fulfilling or achieving the SDGs, but we are not recognizing a right such as the right to water as a fundamental human right that is judicially enforceable, then we should rather not participate in the SDG discussions at all. Thank you.
Yeah, thank you very much. My line of thinking, I think, was expressed fully by Mrs. Pickering. We have to move together. I thought the principle Ubuntu in the Moshwambo, I think, is onto one. It's principle the same. That when we are moving, we all take all of us together. There must be minimum standards, for instance, for the right to water. For instance, we have drought, and we know people survive on agriculture, on subsistence farming. How do we have them access to water? Where do we limit, or is that are we thinking only the water for people who have moved to the outskirts of the Windhoek, or are we also talking about people who have cattle in a deep forest 30 or 50 kilometers away from the normal water? So the right to water, it's a big thing, and I think if we are going to put it in the perspective that if it's on the principle of Ubuntu or Ubuntu, then we have to come up with workable solutions. And I think those solutions, if we all work together, then legislatively, it can be, I think, achieved. I think courts alone will not in itself maybe, if for instance we impose certain orders to say provide water, for instance, there are many places where we find people are drinking dirty water. We have a scenario in Kavango where people have to fetch water from the river. We have recently we have a pipe problem in Oshakati, and then those centers were not receiving water. But it didn't concern the whole region per se. But those I think are considerations that we take. If we say Ubuntu Ubantu, we must take it in a context of full minimum standards for people to receive at least water everywhere. So those are my comments. Thank you.
Mine is actually a comment. From listening to your presentation, although I just got the book now, it would have been ideal if we got the book in advance, would have been able to comment meaningfully. But from what I heard from your presentation, the right to water, you are anchoring it or locating it on the right to life. I think my view is that if the issue of the right to water, a challenge is brought before court, and the case is properly structured and argued, I believe our courts can grant that right to the litigant or an applicant. If we have regard to the principles which were laid down in the case of State versus Club, I don't know whether I'm pronouncing the name correctly. That was the case which dealt with the right to life in respect of a prisoner who was sentenced to life imprisonment. The prisoner went to court claiming that life imprisonment means that he will die in prison, he will never be released from jail. Because of that, the sentence of life imprisonment violated his right to life. The court ruled that life imprisonment in Namibia does not amount to a death sentence, or that a prisoner will die in jail. The court held that there are alternatives. For example, a prisoner who is sentenced to life imprisonment, they can be released on parole after they serve a sentence. I think it was for after 25 years, they can be released on parole. So if an argument is presented before court that a person does not have the means or the alternative to have access to water, I believe the court can order the state to provide water to that particular individual. However, if there are alternatives, for example, we know that in regions, I think through regional councils, government digs boreholes in villages around villages. Old people, pensioners, they get pensions. I think if a litigant can prove before court that there are no alternatives on how they can access water, there are no alternatives on how they can access water, and if they do not have water, they can die. I believe our courts will be able to grant such a relief to a person who comes before court using the right to life instead of relying on state policy, Article 95 and all that. I think the book is very helpful. From the table of contents, although I have not gone into the details, a case for access to water through right to life, I believe it can succeed in our court if a litigant is so indigent, poor, that they don't have the financial means. I believe the court will order the state to provide water to that particular person. I think legal practitioners, if we come across through such case, we can test the waters. If we rely on the legal principles in the matter of state versus third, the court can order the government to provide water to a person who is unable to provide water for themselves. That is my comment. Thank you.
My contribution is part comment and part question. On the commentary side is to Dr. Ndeunyema. From the engagement that we've been having here, I can see that the book, your research is very extensive. It touches on quite a number of areas. And one that really stood out to me was the socio-economic aspect. And I think it's a very valuable contribution that you've laid down there for us to consider as legal practitioners. And also it's very provocative to not only us as a fraternity, but to the courts as well. That being said, I want to now go into the question side of things, and I want to direct my question to Judge Masuku. And perhaps if I'm treading on or walking on thin ice, please do inform me and then forgive me. But I look at our court system and the comments made by Dr. Ndeunyema earlier about how far behind the curve we are. It's really a question of, I see the side of the legal practitioners, how important it is for us to bring these things to the court in order for them to be addressed. But how ready is the court system to resolve the issues and move the jurisprudence from where it is today to where we want it to be? Thank you.
I think my answer is the honorable gentleman is skating on thin ice. Well, I think what I would like to say in that regard is that they say that Rome was not built in one day. Sometimes it might depend on the outlook, but firstly, I think you excluded the issue of the participation and the importance of what lawyers have to do in presenting cases to the courts. I think that if you look back, you find that some of what now are enjoyed freely, there's been a struggle and a fight to get people to understand And there must be a level of persistence and a level of enlightenment, not only amongst members of the public and the legal practitioners, but also to the judiciary as well. So what I was even thinking, some people might have different opinions, was that if time was permitting, Dr. Ndjodi would probably have a session just to unpack the book, because when I read it, you need to read it, put it aside, lie down, think. I'm serious, yes, you really need to do that. To read, once you do not think you can just read and understand. Some of the issues you need to regurgitate them, think them over again. And so I think for this to be the success that we would like it to be, maybe a session just to unpack the book. Not that you are trying to influence how judges should, deal with the matter, but just for purposes of them understanding what is contained in the book, which might assist in moving the issue forward. I think that's how far I can go. And before that, after that, it's a slippery slope, which I will not join you in engaging. Thank you.
Evening, everybody. Like our leader of the chamber said, we don't like talking, but as a baby of the chambers, I had no choice. So I'm here. Ndjodi was my classmate in my undergrad studies at the university with our B juries, our LLB. We even used to walk to school together. So I'm super proud of him. And I see he's still very much passionate about the law and making his contribution into the Namibian jurisprudence through his scholarship. Ndjodi's book is a pleasant reminder of the awareness of human rights and just being grateful for these privileges that we sometimes take for granted, especially for some of us that can wake up and go to a tap and you forget that your brother in Havana doesn't have the same privilege, So Ndjodi is making his contribution through his scholarship. So as legal practitioners, and as it has been echoed throughout the evening, it's our challenge then to make our contribution in the law reports. So next time you have your agent against the city, particularly when it comes to these things, then you become a creative then. Let Ndjodi's book inspire you in putting up those analogies for interpretation. And I really like that he uses the approach of Ubuntu, which is really a concept advancing human flourishing, which is the very purpose of human rights advocacy. So, Ndjodi, we really thank you for your contribution. I have been asked to say thanks to the sponsors for the event, Shakwe Nyambe & Co., Nambili Mata, and of course to us, Jakob Marengo. This is not the first time we are hosting an event like this. There has been already other initiatives in terms of lectures. We believe we need to have this more engagement outside the courtrooms, the boardrooms where we are constantly fighting each other, but to just have meaningful legal conversations of other aspects that doesn't involve us fighting.